First of all, I'd like to say good afternoon to all my colleagues here, and we'd be very thankful for this opportunity. So, given our discussion today, when we think about what the legal system will look like in 2047, my colleagues and I, we actually envision a system wherein we don't have to go to court at all. We envision a system which is so digital in nature that we don't have to step out from the boundaries of our house to resolve a dispute. Especially what we think about is we see a system or rather an app or a web-based system wherein all matters are handled, all procedures are taken care of, and we don't have to visit any judicial officer, we don't have to present our case, and it is handled on its own. What this actually looks like in real world right now, we understand that there are physical limitations to this. This will have to be a gradual process in itself. What this means is that basically what we have to do is we have to start introducing digitization as much as we can today. We have some suggestions with regard to the same, right? Firstly, we'd also like to talk about the oversight to legal education. We understand that there are multiple facets to this itself. Like, for instance, that legal education needs to be pervasive, which means that it shouldn't be limited to law schools, but it should come about to schools as well, school students who know systems, right? How we can do this? We can make minor tweaks in our current education policies or minor tweaks in school systems so that children, as they grow up, are also aware of what district courts are, how they function, and what do they need to do in order to, well, approach them in a systematic manner. With regard to the lack of knowledge of students, we recognize that internships are something which has been mandated by the NEP. However, the problem here is that only a number of hours have been mandated, not where you intern or rather what is the kind of exposure that is given to you. We'd like to talk a little about how internships in itself need to be diversified, right? For instance, not just as a law from a law student perspective, even even people belonging to non-law colleges need to have this access, they need to have this exposure, right? How we can do this is we see that there's already a program for the access to the Supreme Court which is mandated on Saturdays. We see that this program can be extended to the high courts as well as the district courts, where we can have school visits as well as college visits from non-law professionals in order for them to come to courts and see how systems actually work. Further, we understand that since digitization is a important mandate here, we can have virtual summons by way of Aadhaar linked emails and Aadhaar linked messages that can go to individuals, right? We understand that there is a gap that exists because of litigants not being informed of the process that they themselves are undertaking. In order to do so, we can have emails and other messenger apps that can inform them of summons, and there can be a deletion of personal information after a certain time. With regard to further suggestions, I'd like to hand over the mic to my friend Ron.
Right. Thanks a lot. So, following from that, one major suggestion, which might be a bit too extreme, is that when we're looking at the judicial system in 2047, we can have judges who are non-lawyers. So, if you look at companies, what are they doing right now is that they are not even going to court. All the companies are mostly preferring arbitration. And one particular reason for giving preference to arbitration is the fact that the arbitrator is not a judge. And the fact is that the arbitrator is someone who is a highly trained individual and has key specific knowledge of the particular fact that he or she is dealing with. And when we're looking at the judicial system in 2047, to ensure that companies can also come under the purview of courts back again, what we can do is just like the government is thinking of introducing lateral entries in the UPSC, we can have lateral entries into the judiciary. Or if the government is not keen on replacing judges entirely, what we can do is ensure that judges also have the assistance of a person who is equally competent. For example, the government has various tribunals that deal in specialized laws. For example, the Securities Tribunal or uh, the other administrative law tribunals that deal with specific acts. And what we can do in the future is that we'll have disputes concerning various technical aspects, such as say blockchain technology, and judges might not be well versed with these areas. So in future, to ensure that companies refrain from going into arbitrations, as we have seen that the records of the government in international arbitrations has not been very good, to bring them back into the foray of courts, we can have non-lawyers as judges in the future. Now, second thing is about this perverse incentives that lawyers also have to prolong litigation. So if I am a lawyer, then I will get more fees if the litigation is prolonged, right? So lawyers will also try to ensure that there are more and more adjournments. That is a perverse incentive that also exists in our procedure. And to fix that, what we can do is ensure that the litigant also knows what is happening with his case in the court. So in my case, I had a personal relative who didn't even know what was happening with his case. And in this situation, what we can do is ensure that after every date, the litigant gets a text message on his phone to know what has happened with his case. For example, if an adjournment has been sought, the litigant gets a message that the next date for your case is this. Now, this will ensure that there is more and more communication between the litigant and his lawyer. So, if the litigant feels that the lawyer is actually expounding his resources and trying to prolong the trial, then he can go ahead and change his lawyer. And this will also ensure that the time that the court is investing in that particular case is reduced. And the last suggestion from my side is regarding mandatory virtual hearings for certain portions of the trial. So currently, the system that we have is that if the COVID caseload is more, then we resort to virtual hearings. And if the situation is right, then we move to physical hearings. But what we can do in the future in 2047 is that we can look at certain portions of the trial that can be moved to permanently online modes. This means that if, let's say, I am a lawyer and I am challenging the maintainability of a case, then I don't even have to go to court to argue that. This will also ensure that the court does not have to spend its time on listening to basic arguments that say deal with the maintainability of a suit or challenges to the jurisdiction of the court. But let's say if a cross examination has to be done or evidence has to be taken, then obviously the parties can be called to court. And now I'll hand over to my colleague. Thank you.
Yeah, right, thank you. So, as a student who has spent 2 years of a law school online, I've come to realize that integrating AI into our judicial system is something that can be very beneficial. Because as a student of law, I've seen the benefits that digitalization and AI can provide. So, one way in which this can be done, and it might sound too ambitious, and it would need to be fleshed out by people who know the nitty-gritties of practical judicial system, is that the promotion of judges and the filling of vacancies can be done through an AI driven system. For example, promotions should be something of a general norm, and the exception to this should be that the promotion has not happened. So, the AI in this case can go through the verification of documents that the judges provide, and this also ties in with the four aspirational goals that the PM mentioned, that there should be limitation of the government interference. So even in the sphere of judicial appointments, there should be limitation of how long the government can take in making these appointments. So if there's an AI-driven solution for appointment and filling of vacancies of judges, this will actually help remove this dearth of judges that currently the courts in India are facing. And also this will help in increasing the efficiency and productivity of the court. One example of this is the IT Act. So for example, the section 66A was removed on being unconstitutional as it infringed on the fundamental rights of freedom of speech and expression of the people. Now, if there's a if there's an AI system that sorts through what the cases deals with and gets to know if the filing of the case itself is frivolous, because till this date there are cases being filed on section 66A. Now, if there was an AI driven system which already points out that this is something that cannot be done, that this is something that cannot go forward, there will be this reduction in caseload and pendency that the courts today face. And with that, I would like to rest my suggestions. Thank you.